Privilege.
Senator Hirono.
I would request that my colleague, Senator Cruz, not misstate what I'm saying. And you know what? All this mansplaining, please stop. Thank you.
Senator Padilla is recognized for 5 minutes.
Thank you, Mr.
What
Chair.
what was
Thank you
mischaracterized, Senator
to-
Hirono? You just said I
Gelpi.
mischaracterized something. What?
The floor is mine, Senator Cruz.
Senator
I'm
Padilla
very
is
proud you have a
recognized
gavel,
for 5 minutes.
but a point of personal privilege. Senator Hirono just said I mischaracterized something she said. So I am asking her what was mischaracterized. You are welcome to explain what
Mr.
was
Chair.
mischaracterized.
All right, guys, welcome back. I just watched this clip from the Judiciary Committee hearing, and honestly, this is one of the sharpest cross-examinations I've seen in a while. Cruz walks in, asks simple, direct questions, and the nominee just can't get out of it cleanly. What's wild is Hirono tries to frame originalism as this scary thing that only exists to overturn cases she likes. Then Cruz calmly turns it around and says, basically, okay, name me a case you don't like the outcome of. Let's see if you're consistent. That's where it gets interesting. We're going to break down the whole exchange because there's a real double standard on display, and I want you to see it for yourselves. If you're into these hearing breakdowns, hit subscribe, drop a like, and let me know in the comments if you caught the moment I'm about to talk about. Let's get into it.
Thank you, Senator Kennedy. Senator Hirono is recognized for a comment.
Thank you very much. There were a lot of questions asked of this nominee relating to originalism, and the way I see it is this was an effort to get Judge Helpe to acknowledge originalism as the only way to do either constitutional or statutory interpretation. He did not allow himself to be boxed in this way. And we all know that statutory interpretation, there are canons of construction. We all learned that in law school. And then as for applying originalism in the constitutional context, if originalism were applied, I think that Obergefell, for example, that protects same-sex marriage would not have been decided in that way. And in fact, it's one of the reasons that Justice Scalia was a dissenter in that case, and one of the reasons that both Justices Alito and Thomas have indicated that they would like to revisit Obergefell. And if originalism were applied, I would say that that really puts into jeopardy the decision in Roe v. Wade, which protects a woman's right to choose. So all of this effort to try to box this nominee in is seen for what it is as far as I'm concerned. Thank you, Mr. Chairman.
Thank you, Senator Hirono. Senator Cruz is recognized for 5 minutes.
Thank you, Mr. Chairman. Judge, congratulations on your nomination.
Thank you, sir.
As a sitting federal judge, you wrote a book entitled The Constitutional Evolution of Puerto Rico and Other U.S. Territories. In that book, you're highly critical of the insular cases, a series of opinions from the Supreme Court in 1901 that addressed the application of the Constitution to territories where the United States exercised sovereignty. Specifically, you describe these cases as, quote, a doctrine of pure judicial invention with absolutely no basis in the Constitution and one that is contrary to all judicial precedent and territorial practice. Later, in 2011, you concluded a Spanish-language academic article on the insular cases by saying, quote, it is now the hour, and indeed it has already grown late, for the Supreme Court to re-examine and remedy this offensive and obsolete judicial dilemma, which we have had to tolerate for more than 100 years by over 5 million American citizens who live in Puerto Rico and other territories of the United States. I take it then, based on your writings, that you believe the insular cases were wrongly decided.
Senator, yes, when I wrote in those academic books about the insular cases, I've discussed it from an academic perspective, and I've made reference to the fact, particularly, that the insular cases were decided by the same Plessy versus Ferguson Supreme Court, and that they considered racial, ethnic, discriminatory matters, and the same Supreme Court took that into account. Those are matters that nowadays I don't believe any member of any branch of Congress, of the government, would take those matters into consideration. So that is my criticism of the insular cases. In cases that I've had before me, I apply the doctrine as it still stands. That is the law of the United States, whether I like it or not.
So you've said you believe the insular cases were wrongly decided. Do you believe Brown versus Board of Education was rightly decided?
Senator, I believe it was rightfully decided, yes.
Okay, what about District of Columbia versus Heller?
Senator, that is a case that is the law of the land. I have to apply Heller, I have to apply McDonald, and it is the Supreme Court doctrine, which I will apply.
Well, I understand that, but that was not the question I asked you. You just told us you believe the insular cases were wrongly decided. You just told us that you
Not the insular cases. Oh, yes, excuse me, yes, sorry.
that that you believe the insular cases are wrongly decided. You just told us that you believe Brown versus Board of Education was rightly decided. So I'm asking you what your views are on Heller versus District of Columbia. Was it rightly decided or wrongly decided?
Well, Senator, as I mentioned, that is the law of the land, and I am aware that there are other challenges that will be upcoming, and there's one in California. That similar challenge could be before my court or the Court of Appeals. So that is something that, as a sitting judge, and that is a controversy that is live and ongoing, so I should not decide that. But I will apply Heller and McDonald. I can guarantee you that.
Well, you were a sitting judge when you wrote about the insular cases, correct?
Senator, yes, I have criticized historically the underpinnings of the insular cases, but
Well, not just the underpinnings. You said flat out they were wrongly decided and the Supreme Court should reverse them. That was not just an academic observation. That was calling a decision wrongly decided and saying it should be reversed.
correct, a decision based on racist underpinnings. I agree with you.
And Brown versus Board of Education, certainly questions about race and litigation about what equal protection under the laws means. That litigation continues in courts across the country today. Is that right?
Not the Brown holding.
But the principles on which Brown was decided, those are actively
There are
litigated issues.
particular equal protection cases filed in federal courts every day. That's the purpose of federal courts.
So how about the Citizens United case? Was that wrongly decided?
Senator, that is the binding precedent, and that is something that I could have a similar case in the future. But again, that is the law of the land. I have to apply it.
So it seems on cases where I'm not clear what your standard is for when you will answer what questions were wrongly decided, what cases were wrongly decided, and what cases were not.
Well, Senator, I can tell you, historically speaking, Brown, I can say, was correctly decided. The insular cases, historically speaking, the rationale behind those cases was based on racist underpinnings. I have to say that rationale was incorrectly decided. As a matter of
So
history.
Senator Hirono just offered a defense of you, saying that you refuse to commit to originalism because originalism would prevent outcomes that she supports. It would prevent outcomes in cases like Obergefell and Roe versus Wade, and because she supports those outcomes, she doesn't want judges who will follow the original understanding of the Constitution. Is that how you would articulate? Well, is it right that you don't intend to follow the original understanding of the Constitution?
The senator's time has expired. Judge, you may answer the question.
Senator, as I mentioned to an earlier question, I will apply originalism, and that is one of the factors or the tests that the Supreme Court has laid out for judges to follow, and I cannot ignore it. I have to follow originalism in the cases where it is appropriate.
But do you agree with Senator Hirono's
Senator's time
defense
has
of you,
expired.
that those are the reasons?
The senator's time has expired. Senator Padilla is recognized for 5
You know,
minutes.
this is a committee where we've had a little bit of comedy, and I recognize
Chair.
that Senator Ossoff
My
is
time.
new, but we
Chairman.
generally don't have the chairman trying to jump in
Point of
30
personal
seconds
privilege,
in.
Mr. Chairman.
Thank you,
And I
Senator.
My
recognize
time.
the chairman
The floor
may
is
not
mine.
want these
Senator
questions
Cruz, the floor is
answered.
mine.
Point of personal
Thank you.
privilege, Mr. Chairman.
There'll be order in the Judiciary Committee. Senator Cruz, your comment is noted, and Senator Padilla.
Chairman,
Thank you,
point
Mr.
of
Chair.
personal
Thank you,
privilege.
Mr.
Chairman
Senator
Ossoff
Padilla,
desperately
out of
does not want
respect
these
to-
questions answered.
Point of personal privilege.
Senator Hirono.
I would request that my colleague, Senator Cruz, not misstate what I'm saying. And you know what? All this mansplaining, please stop. Thank you.
Senator Padilla is recognized for 5 minutes.
Thank you, Mr.
What
Chair.
was
Thank you
mischaracterized, Senator
to-
Hirono? You just said I
Yelp.
mischaracterized something. What?
The floor is mine. Senator Cruz.
Senator
The floor-
I'm
Padilla
very
is
proud you have a
recognized
gavel,
for 5 minutes.
but a point of personal privilege, Senator Hirono just said I mischaracterized something she said. So I am asking her what was mischaracterized. You are welcome to explain what
Mr.
was
Chair,
mischaracterized.
Mr. Chair, Mr. Chair, is the floor mine?
Okay, so you're not going to explain
Senator
what
Cruz.
claim was mischaracterized.
May I
Everyone
proceed
bear
my
with me.
questions?
Senator Cruz, you may respond to Senator Hirono.
I described what Senator Hirono said. I asked the judge if he agreed with her defense that he should not embrace originalism because it would not allow him to reach outcomes that she favored. She's now come back and said that was a mischaracterization of what she said, and so I'm inquiring, what is mischaracterized?
Mr. Chairman, very briefly, because otherwise, the thing with my colleague is he always has to get the last word, and that is a fact. But one of the ways mischaracterizes that I do not object to originalism as applied because it results in decisions that I don't agree with. I disagree with the way that the court proceeded in some of the members of the court and how they proceed with the originalism to get to the results that they want. So that's it.
Is it not accurate that you said you thought originalism
Mr. Chairman.
shouldn't be followed because it would lead to a different result in Obergefell and a different result in Roe? Is that not what you said in this committee just a few minutes ago? Okay,
Some of
well, the
court
record is clear.
Some of the court members apply originalism, not all of them do, and that is why in some instances they have been in the minority.
Well, the
maybe
record
not
is
so
clear
much
what you
now.
said, and now you're saying you didn't
Mr.
say
Chairman,
it.
thank you.
Thank you
your
for this
indulgence.
exchange, senators, and Senator Padilla is recognized for.
Okay, so let's talk about what just happened, because there's a lot here. First, Hirono's framing. She opens by saying the whole originalism questioning was just an attempt to box the nominee in. But then she immediately explains why originalism is inconvenient for her. Applied consistently, cases like Obergefell and Roe don't hold up the same way. She basically makes Cruz's point for him while trying to deny it. Second, the consistency test. This is the real substance. Cruz doesn't ask some vague, "Do you believe in originalism?" question. He asks about specific cases. Insular cases? Wrongly decided, no hesitation. Brown versus Board? Rightly decided, no hesitation. Good, consistent so far. Then Heller comes up. Suddenly, that's the law of the land. I have to apply it. Citizens United? Same dodge. That answer would have been fine if he'd said it for Brown, and the insular cases too. But he didn't. He gave real opinions on the cases that fit a certain lean, then hid behind precedent the second it got uncomfortable. Cruz says it plainly. I'm not clear what your standard is for when you'll answer. Honestly, same here. Third, the racist underpinnings pivot. The nominee justifies criticizing the insular cases by pointing to their discriminatory origins. Fair point. But Cruz notes Brown deals with race too, and the equal protection litigation from it is still active in courts today. So why is one fair game to critique and not the other? The "this one's historical, that one's still live" excuse doesn't hold up evenly. Fourth, the Padilla and Hirono interruption. This moment says a lot too. Hirono jumps in accusing Cruz of mischaracterizing her. But when he restates almost word for word what she said, her response is basically, well, some justices apply it wrong, not all of them. That's a walk back, not a correction. Bottom line, Cruz isn't asking anyone to prejudge cases that might come before them. Nominees legitimately can't comment on pending matters. But he is asking for consistency, and that's a fair standard for any judicial nominee. You don't get to state clear opinions on the cases that suit you and then hide behind restraint the moment it's inconvenient. That's what this clip exposes, and I think Cruz handled it well. Let me know what you think in the comments. Did the answers feel consistent to you? Drop a like if this was useful, subscribe for more of these, and I'll see you in the next one.